Well, good afternoon or good morning, as the case may be. Friends, this is Casey Gwynn, the president of the National Family Justice Center Alliance, and we're happy to be having you join us today for this webinar on U-Visa practice. We're particularly excited about our panel of presenters and our team of experts as we dive into this. But on behalf of Gail Strack and our whole team, I want to welcome you to this webinar today. This is one of the monthly webinars hosted by the National Family Justice Center Alliance. Gail Strack was scheduled to be hosting this webinar, but I'm just recovering from illness, and I think Gail's got her own illness challenges today, so I have stepped back in and am happy to be part of this today. We always like to give a shout out to our small team, and we like to recognize our sponsors for our webinars. This webinar is sponsored by the U.S. Department of Justice Office on Violence Against Women. We host webinars regularly as a OVW technical assistance provider for family justice centers and their allied agencies and folks working in the civil and criminal justice system on issues related to domestic violence, sexual assault, and stalking and related issues. And this is one of those webinars focusing on this key area of U-Visa practice, and an area that is very near and dear to our hearts, particularly coming from the standpoint of the needs of survivors of violence and abuse who need those protections that come from federal law that are too often misunderstood by law enforcement professionals and others, and too often not readily accessible and available to victims when they need them. And we have pulled together a team that really knows these issues today in order to dive in very deeply. So if you're joining this webinar and you're involved in civil legal practice, or you're involved in a law enforcement agency doing U-Visa certifications, we welcome you. If this is not a topic that you know a lot about, I think you'll still find it incredibly interesting. We always give a shout out in our webinars to our annual conference that we host every year. We are hosting that conference this year in San Diego, our big international conference, which will bring in folks from Canada and Europe and Mexico and all over the United States. Is well underway with registrations. We're into the many hundreds now, and we still have capacity at our main conference hotel, which is the San Diego Hilton Bayfront Hotel, and we'd love to have you join us in just a few weeks. Our early bird registration actually ends very shortly. We want to highlight that. February 28th saves you a little money on registration. We have already many teams registered. We also want to mention our webinar process. We record each of our webinars. Those webinars are available to you after this broadcast. We post them in our online resource library that's available to our 11,000 members and to others that are interested in the content of this. The beauty of that is that when you hear this today, if you feel that there are others that can benefit from it, or if you want to pull together a group of folks and later listen to the webinar again, you're able to do that by going to FamilyJusticeCenter.com, going into our resource library, and accessing it. We also have continuing education credits. The National Family Justice Center Alliance is an MCLE provider in the state of California. While there's not reciprocity in many states, there are processes in place that allow you, with all of the documents that we prepare as an MCLE provider, to take the information from this webinar and to get MCLE credits if you're a lawyer in another state outside of California. You will get a checklist at the end of this webinar that will be emailed to you to allow you to pursue CLEs, MCLEs if you're not in California. Our presenters today are listed on the screen. They're a tremendous panel of experts. Susan Briel is a judge in the Superior Court in San Francisco. Susan was a domestic violence prosecutor for many years, had a very distinguished career in the San Francisco DA's office. I've known Susan for a long time and have an enormous amount of respect for her. She's done work not just in the United States, but in other parts of the world as well, and has a lot of experience in her work in dealing with undocumented, battered immigrant women as victims of domestic violence. So we're honored to have Susan with us. Wanda Luchabello, who's the chief of the Special Victims Division in the Brooklyn DA's office, another good friend, and has been doing this work for a very long time. Wanda is very much a national leader, has done a lot of work nationally for the National College of District Attorneys, does a lot of work with the Office on Violence Against Women, has done work around the world with the State Department, has a lot of awards, and Wanda was really one of the visionaries behind the Brooklyn Family Justice Center, and also teaches law school in her spare time. So we're happy to have Wanda with us. Mike Agnew does a lot of work with us with our Training Institute on Strangulation Prevention and a lot of other work, a tremendous career in law enforcement, almost 40 years with the Fresno Police Department. So we're honored to have Mike bring that law enforcement perspective. Jonathan Moore is with the Board of Immigration Appeals and has done a lot of work with the Washington Defender Association's Immigration Project. Jonathan brings that perspective that we are providing in this for folks that are working from all angles of this issue around U visas and immigrant legal services, and it's really truly an advocate on the complex issues that immigrant victims and immigrant women and men deal with in the criminal justice system. So we're honored to have Jonathan with us. He too has done a lot of work with OVW and has served as consultant for ASISTA, the clearinghouse for advocates and attorneys working with immigrant survivors of domestic violence. So Jonathan, welcome. And then finally, Gail Pendleton, who I'm going to turn this over to now, is our host for the panel of presenters. Gail is really one of the leading experts in America on this whole issue that we're dealing with today around immigration legal services. She serves as the co-founder of the National Network to End Violence Against Immigrant Women and is the co-director of ASISTA, which I just mentioned, which is funded by OVW. Gail's a friend of the Alliance and has done a lot of work with us over the years, and without a doubt is one of the leading experts, as I said, in the country on these issues. She's received many awards. She is a graduate of NYU School of Law and got her AB at Harvard. And so we're very honored to have Gail joining us. Gail, I'm going to turn it over to you. Thank you. Dive us into our topic today.
Okay, thanks, Casey. Before I get into this, I just want to clarify a little bit who Jonathan is. It is confusing. He's not actually a lawyer. He's a Board of Immigration Appeals accredited representative, which the reason I wanted to flag that for all of you is that if you don't know, in the immigration legal system, non-attorneys can practice immigration law, and we actually have a special project with 4 OVW grantees with the Catholic Legal Immigration Network that can train up domestic violence and sexual assault advocates to actually do these U cases. So let me know after the webinar if that's something you're interested in, and I can plug you into our system for doing that. So I wanted to clarify some things before we got into this. The reason I felt the need to pull this together is that I don't know if all of you are experiencing this yet, but we imagine you will start experiencing this the more that you start doing U visa cases, and those cases are ending up in criminal court, which many of them should be, since one of the goals of the U visa is to help law enforcement as well as to help those immigrant survivors who are helpful to law enforcement. And what's become clear is that there really is no one right answer on how to handle this from the perspective of anyone involved in the system. So the goal of this initial webinar is really to bring together these experts, as Casey says. These are the leading experts around the country on all these different perspectives, and do some brainstorming and start the conversation going about what strategies work. And we're hoping that from this we'll actually come up with some next steps that will lead to samples and materials and sharing of strategies that people are trying, and hopefully some more webinars down the line where we can get into more of the nitty-gritty of the different strategies that we've come up with. One caveat is that this is not going to be a basic training on U visas. We have done some of those for the Alliance, and I think you could probably find those in the resource section, or if not, you can certainly find them on the ASISTA website. We also record all our webinars, and because we are funded by OVW, we can help any of you that either work for an agency that gets OVW or state stop money, or partners with any of them, which I think will cover most of you who are listening today. Having said that, I am going to give you a little overview about what's happening now with now that the cap for the U visas has been met, and we've asked Mike Agnew, who is really experienced certifier of U visas, to provide some perspective from a law enforcement angle on why he has found and in what ways he has found the U visa to be helpful. And then we're going to dive into these questions about what do you do when someone is trying to get copies of your certification or your case in court. Now, one other caveat is I'm not sure, this is the first time we've done this, so I'm not really sure we're going to have a lot of time for questions and answers at the end, but we will definitely get back to you. If you send questions, we will get back to you after the webinar, and we will certainly use any suggestions or questions you have to figure out next steps, both in terms of materials that we need and webinars that might be useful to you. Okay, Natalia, let's try the next one, U visa eligibility requirements. I'm just going to do a very brief overview just so we all are on the same page. You have to be a victim of a qualifying crime. We're going to get into what those are on the next slide. You have to show you've been helpful in an investigation or prosecution, and those first two requirements are primarily shown by the law enforcement certification, although you would probably be submitting some other evidence as well if you have it. You also have to show to get a U visa that you suffered substantial harm from the crime, and that's, for those of you who are domestic violence or sexual assault advocates, that's where you really come in to helping get the story from the survivor and find other credible sources of information about the harm that the person has suffered. And then for the lawyers in the audience, this is really the big job for you with the U visas, is figuring out whether the applicants are inadmissible under the grounds of inadmissibility in the immigration law, and if so, can you argue successfully that it's in the public or national interest for the government to waive it. Okay, let's move on to the list of crimes. We'll review those. It's a long list of crimes. I can tell you that, because one of the things I do since 1997, I've been the liaison for the immigration field with Legacy INS and now Citizenship and Immigration Services, and what they have told me is still the vast majority of U visas are granted first in domestic violence cases and secondly in sexual assault cases. But the other, so you know, the other areas that I would say are emerging areas are the felonious assault. We're seeing, particularly, for instance, in California, that robberies may qualify as felonious assaults. And witness tampering is coming up a lot in workplace violations and assaults against people in the workplace. So those are just things to keep in mind. Oh, and finally, I think a lot of trafficking victims who may not qualify under the federal trafficking law or can't get federal certifications are getting U visas as trafficking under state laws. So I think we were going to ask a question now, Natalia, just to get a sense from you all. If you filed U visas, is it on, have you filed, how many of you have filed U visas or worked on U visas, since some of you may not be attorneys? How many have been involved in U visas based on domestic violence? And so, Natalia, do you need to explain to them how to do this?
Nope, looks like everyone's answering. I'll just go ahead and give folks just a few more seconds to respond.
Great. Okay, we've got 0%. That's what I'm seeing.
Here on my end, I have 61% have said yes and 39% have said no.
Okay, so a majority of you have done that. Okay, so then let's try the next one. You may have to read the answers, Natalia, since we seem to be getting the 0% thing. Okay, how many of you have been involved in U visas based on sexual assault?
Okay, again, just a few more seconds, and I'll go ahead and close the poll. And I'm going to go ahead and share it. Looks like we have an even split of 50% yes.
Okay, great. So we didn't ask how many of you have never done a U visa, so I just want to say to you, I hope you find this interesting, since we're not going to do much training on the actual U visa, but I think the whole discussion of how to deal with the with whether to reveal immigration information in your court cases will be helpful to you regardless, one way or the other. So just an update on the cap. For those of you who don't know, Congress has limited the number of U visas for the actual victims of crimes to 10,000 a year. Most victims can include their children or other very close relatives, depending on their relationship. And those, what we call derivative visas, because they derive from the primary victim, there's no cap on that. But the cap for this fiscal year, which runs from September to September, was met within a month, which to me shows that this has become a very useful tool for law enforcement, that they used up the 10,000 visas so quickly. This has happened actually in every year, not this quickly, that the visas have been available, which has only been 4 years because it took the government about 8 years to actually implement the regulations. And so during what they've done is figure out a way to to avoid discouraging victims for pursuing U visas based on whether they're going to, not knowing whether they're going to actually get a visa or not. So the way the system they've got set up now is that for basically until next September, if you're helping with a U visa and they think this is someone that would be granted if the visas were available, they will issue what's called a conditional grant, and you'll get a notice that says this person, the victim, is eligible for deferred action and that they can now apply for work authorization based on the deferred action. And then once the visas become available, assuming nothing else has happened in the case, that they haven't committed new crimes or something that might, prevent them from getting status based on those inadmissibility grounds I mentioned, they're likely to actually get a visa when the new 10,000 come around next October. So that's why I have that last bullet point, is that you need to keep a watch on the people you're working with. Make sure they contact you if anything comes up once they get their conditional grant and before those visas become available. And that's generally true for those of you who do U visas generally. Since after 3 years in status you can apply to get a green card, you're going to want to keep track of them, what's happening, because with a U visa, you may be able to cure a lot of problems that you think you might not be able to cure, including them committing some crimes. And again, it's going to go back to that public interest and how helpful were they to law enforcement. And that's one of my jobs as the TA provider on immigration for OVW grantees, is to help you figure that out in your cases. So one thing I always say when I'm training is never take no for an answer. Talk to us first, and we'll figure out if we can get you to yes in most of these cases. Now, for those of you who work on U visas, you know that often the biggest barrier is getting that law enforcement certification. So, Natalia, let's turn it over to Mike now and get his perspective as a law enforcement certifier on the U visa.
Thank you. I just wanted to add also, before I get into my material, is that even though I am retired, the Fresno Police Department asked me to come back as a volunteer status, and I still am the designated person at the department to review the U visas. And so currently, or I should say last year, I reviewed a little over 200 applications, and this year it's looking like, based on what I've seen already, I'll probably be close to 300. So the numbers are tremendously increasing as the word gets out and spreads about the U visa program. But I think what's interesting is that, and what causes so many problems for people trying to seek U visas, is that really there is no obligation by law enforcement to sign a U visa form. And so a lot of the victims throughout the country, they may have made a police report with an agency that just does not recognize the program, or they have very stringent guidelines on which U visas they will sign. And I'd like to say that I try and follow the guidelines that are provided to us, and we're pretty open about which ones that we sign, and we let the people down the road make the final decision on how this is going to happen. But I think the best reasons on law enforcement being involved and having us sign these U visas as that first step is that really it builds a trust between the entire community, especially the community that is here probably on a basis where they feel like they're in fear of deportation, because they hear that all the time from their abuser in a domestic violence relationship or in a sexual assault relationship, that if they are reported to the law enforcement, that they will be deported, or that the children will be taken away, or Child Protective Services will be notified. So I think that trust and that connection is one of the most important things. But it allows the victims to feel safe when they're reporting what's happened to them without being afraid of their legal status. And as every community in our country, there are groups of people that do prey on people that are within the community that are here illegally, knowing that they are probably not going to notify authorities about the crime that they committed against that person. So it's a great tool for law enforcement to help us identify that segment in your community that does prey on victims who are more vulnerable than people that are here in the country legally. And I have had occasion from people requesting U visas where they had dropped off the radar and our prosecutor's office was not even aware of where they were. And so the case is pending in the court system and they don't know where the victim is, and they do need the victim to come to court. So you can request the victim to contact the district attorney's office and make that connection again. And so we're able to reunite the victim with the prosecutor and keep the case active in the court system without having to dismiss for no victim. And I think the most rewarding thing for me is that when I do sign the U visa and give it to the victim or their attorney who's representing them, that the victim has that sense that now they have a path or an avenue to get out of an abusive relationship, because they can now legally work somewhere within our community and not be in fear of being deported. And so the majority of the U visa requests that I get here in Fresno, there really is no criminal court case pending. And what I've seen a trend here is that people are just going back to old police reports that were made on cases that were closed or never filed and requesting U visas on those cases. And so it's not really an issue there on trying to keep the victim connected with a prosecutor. And then as I had mentioned there about the locating the victim, this is a great way to reconnect the two of them for the case that is still active in the court system. And the threats by the perpetrator of deportation, that's a big factor on victims not wanting to report. Well, what I have found is that when I get a U visa request, especially from a domestic violence victim, I can usually always find prior police reports made before the one that they're asking about of violence between this victim and the perpetrator. And I always try and include that information within the application about the victim's helpfulness in areas showing that they have reported in the past. And I'll show you on the next page here a little example of how this looks in not only our follow-up investigation to the DA's office, where we want the prosecutor to be aware of the case, but this information here is also given on the U visa application either as an attachment or within the section of the report that talks about their helpfulness here. But you can see the most recent event on 11/27/12 at the bottom is a misdemeanor domestic violence assault case, and the suspect was arrested, and it was that case that prompted her to report the incident and request a U visa. But I really feel like we're doing a disservice not only to the victim in the court process, but also in the U visa application if we don't talk about the two police reports made before that, where she did notify law enforcement, and there are things that occurred within those two events that at first glance may appear as though they're not cooperating because she is back together with the abuser. Those things need to be looked at later on down the road by other people in this process, because we all know that work in domestic violence, that this is normal behavior for a victim to return to an abuser for a variety of reasons. So that would not be a reason for me to not sign a U visa for a victim simply because they had returned to an abuser.
So I have a question, because you had mentioned that many of the cases you get may not be actually going to court and may be a little old. In what way do you think that those people are being helpful, given that there's no current case that they're being helpful in? What do you say? What do you say about them in terms of how they've been helpful to law enforcement?
In the case that they did make to us, and I have gone back almost 20 years to a police report, where because there is no time limit for a U visa. I look at everything they did in that report. So if they called the police to report it, if they provided details of the assault, if they provided a description, if they allowed injury photographs, if they stated they wanted to pursue charges, those are all things they did that were helpful for us to identify a perpetrator in a crime and we're creating documentation. Now, that case may not have ever been filed by a prosecutor's office, but again, that's not a factor we look at. I look at their level of cooperation in that case, even though it's done with.
Okay, and I guess one thing I'm thinking while you say that is I like the way you framed kind of the big picture. I assume one of the reasons you think it's important to help those who even don't have current cases is it builds that trust of the community and they know they can come to you?
Yes, yeah, I think that's really the biggest reason is you're building up a connection, a trust, a relationship with a large segment of your community, the people that live and that you work with, you work around. These are the same people whose children are probably going to the schools that your children are going to. You're shopping in the same places. You're driving down the street together. So we're all one community, and if you isolate them and don't make them a part of it, you basically create two different cities within a city.
Thanks.
And so what law enforcement is certifying, I think this is becoming more and more challenging as the word gets out about how to get a U visa. It needs to be the qualifying criminal activity, and domestic violence is still the #1 crime that people are reporting to us as requesting a U visa for. But I'm seeing a tremendous increase in the felony assault area, where people are reporting that they were assaulted by someone years ago, and they're requesting a U visa for that under the felony assault category. So it's important that every agency develop their own policy, protocol, procedure on what they're going to deem as qualifying criminal activity, because the way the code section reads, it's anything similar to the list of codes that they provide to us. So you're going to see agencies are going to view things differently. I mean, I could say, yes, it's a felony assault in my community, and in Northern California, another law enforcement agency may say, no, it's not. And then the second thing is we look at their helpfulness in the investigation. Have they continued to be helpful? And if the case is still active, are they likely to be helpful in that case? So I start with the investigation for their helpfulness, and if it moved to a prosecution phase, I want to see if they were helpful in that phase also. But they don't have to have prosecution to get the U visa signed. Many of our cases are closed out without the prosecution process. And then just a comment there was about that chronology page, which I already covered there. So things that we are not going to be certifying, just some things to be thinking about is that we're only looking at a portion of this U visa application that has to do with qualifying crimes and helpfulness. And so some people within the system that in law enforcement, they have the belief that our signature is granting citizenship, and really there is probably a dozen extra pages of material that we don't see that is reviewed and researched by people down the road. And so we are not granting citizenship. We are only certifying that this is a victim of a qualifying crime and they were cooperative. Substantial harm is something that must be shown, but it's not really something that law enforcement has to get into. If you have a victim with injuries, yes, we do want those noted in the form as to the description of the injuries that they did suffer, which typically is physical injuries. I would never get into discussing psychological trauma within my form. That's coming later on from someone else. Most of the people that I sign U visas for have other criminal issues in their background. Probably the most common is the traffic violations, driving without a driver's license, driving without current registration, those types of things which do not stop me from signing a U visa. And again, the other crimes a person may be involved in are looked at down the road by someone else, and they can look at those issues of whether they can waive the inadmissibility problems.
If you don't mind, Mike, this is Gail. If I could just interrupt 1 second.
Yes.
So you know, those of you out there, since I do this liaison and see a lot of cases, really most of the cases that I see denied are denied because of the lack of harm or because they're inadmissible and can't show the waiver. So it really isn't related to the law enforcement certification. It is that other proof that Mike was talking about.
Right, yeah. So just again, I want to re-emphasize this, that if you are law enforcement signing U visas, that you can't just simply read the police report and base your entire decision based on that one report. You really have to do the history work within your agency and look at prior calls involving this victim and perpetrator. And what's interesting is once in a while you'll get calls that are later on down the road, more recent, and in those cases the victim has been cooperative and just didn't mention the case, but in some cases the victim has been found more recently to be totally uncooperative, and that's going to cause a problem there for us to sign a U visa for the victim, because basically they're just picking and choosing cases from the past that are no longer active, but they're more recent cases. They're not cooperative with law enforcement. I also look at the address of the victims, because many times you'll see calls from the victim to law enforcement requesting help, wanting to report something, and officers respond, but no reports are generated for a variety of reasons. So those can be documentation that you would want to include with your U visa form. And then your perpetrator's criminal history many times will show not only violence against this victim, but you'll see violence against other victims in prior relationships, which might be significant into your U visa certification. The U visa certification process by law enforcement, if you can think about it this way, I think it helps motivate us on what we do for those of us that sign these. It's really the first check against fraud and abuse of this system. And I'll share with you the U visa I picked up yesterday. Yesterday I went into the office and I picked up 12 new applications, and that's just for this week. But one of them was a person who had been involved in a traffic accident, and he was requesting a U visa for the traffic accident. And when he was asked about the crime that had taken place, he wanted to tell us about he had been shot at, but failed to mention to anybody about the shooting for different reasons. So that obviously is not going to be one that we're going to be able to sign, because traffic accidents don't fall under the category of qualifying crime. So we really are that first check against the fraud and abuse of this system here. The law enforcement guide is really a helpful thing. I did these U visas way back in around 2006 is when I started doing them, and I was doing things that I thought were correct, but that guide really straightened me out on some of the things. The case has to be within your jurisdiction. I cannot sign a U visa for another city. So it has to be a case that will fall under your agency's jurisdiction. And again, there's no requirement for us to sign a U visa. You really should have a letter from your head of your agency that signifies you are the designated person, and every U visa you sign should have a copy of that letter that goes with it. I learned...
Mike, can I just intervene a second on that? Because I think a lot of people don't realize that, because it's not actually in the regulations yet. But because what the regulations say is it has to be signed by the head of the agency or a supervisor. But what CIS has agreed to is that in Mike's situation, where he's been designated by the head of the agency to be their U certifier, you just get a letter from the head of the agency on letterhead and then attach that letter to every certification that Mike supplies. So it doesn't have to be someone with supervisor in their name.
Correct, right. And there's a sample letter within that guide even, if you need to get one of those created by the head of your agency. Your signature should be in blue ink and not the black ink that I used to use. Found that one out within the guide. You really have to have a system of keeping track of these cases that you're signing and cases that you're denying, because I find that people will attorney shop, and they will be denied by one request, and they'll just simply change attorneys, and 6 months later you'll have the same person with a different attorney requesting a U visa. So it helps to keep track of the ones that you deny as well as the ones that you sign. They're only good for 6 months once you sign them, and some of the clients that we work with, for a variety of reasons, they don't get them turned in time, and they basically expire. And so they need to have a new signature. So if you are saving these in a computer system, it's really simple just to bring it back up and sign a new one with a new date, and it speeds that process up.
And by the way, the reason they want it in blue ink is so they know it's an original certification.
Correct. The people that come in and request the U visas, and I'm seeing more of this now because the word is spreading, they're trying to do this on their own, and one of my goals is to make sure they get hooked up with somebody that can assist them in this process, because it's not something that a person should be trying to go through on their own without help from professionals. And just there's no statute of limitations on the cases, no prosecution is needed, and the case can be closed and we can still sign a U visa for someone that was cooperative. And my final slide, just recommend that whether you're law enforcement signing or whether you're an attorney that's working with these, there's some really valuable information within this guidebook which you might be able to share with your law enforcement community on signing the U visas. So it's an excellent resource for those of us that sign the books. And that takes us to the next slide, I think.
Yeah, thank you very much, Mike. And I just wanted to let people know, folks at DHS let us know that they're updating that law enforcement guide, which really is a terrific guide if you haven't looked at it. They got a lot of input from law enforcement and from those of us who've been working with law enforcement and have a really good kind of Q&A section that hopefully answers all your questions. But they've asked us to ask you if you have any suggestions for it to let us know, and we'll let them know about things that they can add while they're basically fixing it because the law got changed a little bit in VAWA 2013, and so as long as they're fixing it, they want input on anything else that they should put into it. So let me know if you have any suggestions. Okay, so now let's talk to Wanda, the DA. Wanda and I have done a bunch of trainings together. She's fabulous. I love it. She always has something new to say and something creative. So tell us, Wanda, from your perspective as a DA, how has the U visa been useful for you? And I know that you've changed your practices over time. You want to lay that out for folks?
Sure. It's great to be here today. And I just want to give a little context. I'm from Brooklyn, New York, and our population is about 2.5 million people, and about 37% of our population is foreign-born or don't speak English as a first language at home. So as a domestic violence prosecutor, you have, this big urban jurisdiction with a lot of folks who come from all over the globe and who are really distrustful of law enforcement. They're distrustful of police, of courts, of prosecutors. So it's really having an avenue like a U visa certification can really be the sort of focal point, the hub from which all of these spokes in the wheel kind of come out. And what I mean by that is it really, and Mike was saying this, and I couldn't agree more, this is really like sort of community policing at its very core, because it involves building trust, and it involves having integrity, and it involves having people who are really terrified and really fearful and have all kinds of cultural concerns and experiences from their country of origin vis-a-vis authority, about criminal justice, and the U visa really acts in so many ways to mitigate a lot of that. And I'm fortunate because working as part of a large family justice center, we can work very closely with our immigration attorneys who are on site. And what this has done is it has literally allowed us to prosecute cases that we would not otherwise be able to prosecute, because there's a way when the victim comes in where they are going to literally like check us out. Are we reliable? So they'll come and talk to a prosecutor, and then they'll go down to the hall to the Asian Women's Center, and then they'll ask in their native language of a counselor from the Asian Women's Center, is the prosecutor trustworthy? Can I actually trust this person? And we have had a mountain of success stories that really originate from our being able to issue a U visa certification. So it's really, really important. I actually think it's contributed in some ways to our reduction of our homicide rate, because by doing community outreach with refugee, immigrant, and migrant battered women, we are really, really doing a lot of, you're not alone, there's help available, you shouldn't remain isolated, please come in. So it's really been extremely useful, and we have found that from certain very hard to reach immigrant communities, that by working closely with advocates from those communities, we've been able to quadruple the number of U visa certifications, for example, in our Arabic community. So it's really, really, really important, and by working collaboratively with professionals from other agencies who address special needs of particular populations, I think we're actually able to gain the ability to prosecute cases that we would not otherwise be able to prosecute. So I think it's really, really critical in that regard.
Now, we've talked about this. One of the things I've heard a lot from the lawyers is that many DAs won't sign the certifications until the case is over, and I know you've changed your thoughts on that over the years. You want to share what you've done and why you've changed and what you're doing now?
Yes, absolutely. So, we were signing U visa certs back before the protocols came out. So I want to say it's like, it could possibly be back in like 2001. And we had a small group of us who got together. And, you know, in the beginning, we were conservative. I mean, we were really feeling as though, you know, this whole question of, has she been cooperative? Has she been helpful then? Is she being helpful now? Might she be helpful in the future? I mean, we were really feeling as though we really needed a case to go to conclusion, meaning the case was not getting dismissed, it was a finished case, before we could sign a U visa certification. Now, it bears mentioning that unlike what Mike was mentioning, as a prosecutor, the cases that we're signing on are cases where there are pending criminal matters. So what we were finding over the years is, and we became very persuaded by our advocate community, that we should and could be signing cases even in advance of the case being concluded, and which then, you know, sort of brought us to looking at what issues come up if you sign the case in advance of the conclusion of the case. So then we began to get more deeply into the disclosure issues and things that we'll talk about a little bit later. But some other changes in our practice, as Mike was saying, I think Mike was mentioning that so we have that list of qualifying crimes, and one of the things that we have found, that we've not discovered, but we've come to really be more proactive about, I guess, is so if you don't have, for example, strangulation on that list, or you come from a jurisdiction where there isn't a strangulation crime, then we have to have other creative ways of finding a way to certify. So, for example, if we can charge the quote other box that's on the certification form. So, for example, if it's a robbery and there's no robbery charge, but you can check off other, and you might want to list assault as well, say if it's a strangulation crime, then, you know, so we found better and more complete ways of addressing what's been presented to us. And also, like Mike, we've been realizing that, you know, context is everything, and you do have to scrub the background and the history to find out what, if any, other cases have been around in the past, so that we can have a more complete picture of what's going on in terms of the certification. So
I have a couple more questions for you. And one thing I want to share with both you and the folks on the phone, which is the way that I think that you deal with crimes that you end up prosecuting, even you didn't necessarily charge them, that don't seem to be on the list, is to remember that the list that CIS has is a list of categories of crimes. They don't have to be what they're called. So, for instance, strangulation in a domestic violence context would fit under the domestic violence category, but it's helpful if those who are certifying actually explain that in the certification, so that then the attorney isn't trying to explain what really went on here, why there is a qualifying crime when the certification seems to be certifying something that's not on the list.
Right. And so in New York, for example, we don't have a crime of domestic violence.
There you go.
So there you go. So we have to, use, other categories or explain, how it is that we've come to designate a domestic violence crime when the person actually hasn't been charged with the domestic violence crime.
Okay, so let me just play this out so people understand how this works, and because I do a lot of advocacy with CI on this particular issue. So, for instance, I imagine misdemeanor assaults are typical, right? And so you would say we are prosecuting a misdemeanor assault, and either because of the facts or because of the elements of the crime, that is a domestic violence crime in our state and in this case.
Correct.
And so for those of you out there, that's the way to think about it. And if you have crimes that aren't clearly fitting in one of these categories, contact me and I'll help you think through the legal arguments for how they might fit in one of the qualifying categories. So then the other question I had for you, Wanda, is would you, like Mike, would you sign a certification for someone even if you lost the case?
Absolutely, I would.
Okay, and why?
Well, because the victim has been helpful in the prosecution. I mean, the outcome is out of our control.
Okay, great. I appreciate that. Anything else you want to share on changes in your practice before we get into Jonathan describing why all this is an issue for defense?
Well, I mean, Mike mentioned keeping a database. That's something that, we've had to get much better about. I mean, we've signed over 800 of these so far. So you have to keep track of how many you're signing. Over the course of time, New York City has had NYPD get involved in the signing as well. So that's been a big change for us, because now the cases that Mike was talking about where there isn't a prosecution, somebody has not yet been arrested, they may still be at large. So, now we're having NYPD sign the certifications as well. The other thing we've had to start thinking about, since for us it's getting archived files, it's requisitioning documents. In order for us to turn over a complete file to our immigration lawyers, we need to get a lot of documentation. So we're constantly starting to look around for grant funding where we can be included in order to get some funding for what we've been doing. Because it's one thing when you're not doing that many of them, but it's another thing when you're doing, mountains of them. And then when you're doing mountains of them, I think it's helpful for partner agencies and for us as law enforcement to start thinking about how we can partner together and, perhaps get some grant funding to do it.
Yeah, and I would definitely encourage people with either OVW or OVC grants, these kinds of partnerships are very fundable. I would say grants to encourage arrests would be an obvious target, but even your legal assistance for victims grants, you put in a little piece for your law enforcement partner, it makes it even stronger. And one of the messages I give to the lawyers is don't assume that because they work for the government they have a lot of money to do this work. So. Okay, so is it okay if we move on to Jonathan, then we'll come back to you on how you deal with the discovery questions? Okay. Yep. So, Jonathan.
Hi.
Now, let me clarify for the crowd that doesn't know you where you're coming from, because I don't want people throwing tomatoes at you. We have worked with Jonathan for many, many years. The Washington Defenders Association has been our partners in dealing with particularly victims of domestic violence and other crimes who are being charged as perpetrators. And many of you are probably aware of how this happens normally. I know Gail Strack wrote an article about that, how victims are often getting charged with domestic violence or other crimes. And you can imagine when the perpetrator is the one who speaks the language, and she may have fought back, how immigrant victims are also getting charged. And they also work very closely with defenders, and you'll find, I think, a thing you guys did for defenders on how to identify people they're representing as perpetrators who may also be victims of other crimes for which they might be eligible for a U visa or might be victims of domestic violence and eligible for violence self-petitioning. So just so you know, that's where Jonathan's coming from. But because he does work with defenders, we thought we'd ask him to give the defense perspective on what are the legitimate reasons why defense might be wanting to know what's in an immigration application or the fact that there is a promise of a certification or there has been a certification.
Okay, and I'm also from Brooklyn, although I'm in Seattle. So the right of a defendant to confront their accused, the accuser, is a constitutional right. It's in the Bill of Rights. And part of that is the right to get knowledge about things that would enable you to do that effectively. You know, there's a case, Supreme Court case, Brady, that says the prosecution has to share evidence with the defense that's relevant or exculpatory. So the fact that a person is applying for immigration relief could be probative of a motive. It's one fact. It doesn't mean that, I don't think it makes the person incredible, but I can see that together with other evidence, it can become a sort of important data point. So an example of not an immigration case would be, I guess, if a criminal, it's pretty common for a criminal defendant, a person accused of crimes to be testifying against another criminal defendant, to be cooperating with the prosecution and hoping for leniency in their own charges. I mean, that would be clearly something that the prosecution has to tell the defense that that's going on. So that's why people have a right to ask, are you applying for a U visa?
So that kind of goes to the basic credibility of their story, that they may be just making up the story for the sake of getting immigration status, and they're basically using the criminal court to support their immigration case, I guess.
Right. I mean, most people don't game the system in any context, but, you know, there are always some few people who probably will. An example of how so I called up a defender who works in the municipal court in the DV unit, and he thought of a case where the U visa came in and the charges were dismissed, but what happened was there were lots of factual contradictions and circumstantial things that didn't make sense, and when they sort of sat down with the prosecution and said, like, here's a motive, they said, but actually the prosecution didn't believe the story that the victim was putting out. It just provided sort of a point of information, and that in that case, they dropped the charges. So
then that might be why you would not only want to know the fact of them applying, but want to know the content of what they're saying in their immigration application.
Well, I know that people file subpoenas, and I know that they often get quashed. But I think there are cases where, if the defense can make a case that it's relevant, the judge could look at the evidence in camera, and I suppose if they could decide if it was so relevant that it could be used for impeachment purposes on a witness. In other words, under certain conditions, you're allowed to use, when you cross-examine a witness, and then if you have some evidence that they said something completely different, you're allowed to bring it up, and that would be what people would be trying to explore. And as you said, a lot of times the people who are gaming the system, sometimes the person who's accused of domestic violence is actually really not the main perpetrator of violence in the relationship. People learn that they can call 911 first or whatever. And so, I mean, if the right to confront a witness is something that we all have, the good, the bad, the ugly, the just and the unjust alike. And if a lawyer doesn't fully investigate the case, if they don't really look at everything that might be available to defend their client, if they're not really doing their job, it's really not ethical for them to say, oh, I won't investigate that because I feel sorry for my client's victim or something. I mean, that would be unethical.
Right. So I guess what I would suggest for people who are having trouble seeing any legitimate reason why defense would do this is to think of clients where they've been charged with a crime they didn't actually commit, and that this would be something, if you were zealously representing them, you'd want to do. Are there any other thoughts you have on this before we move on to see how people are dealing with this, and if they're dealing with it?
Yeah, I mean, I think the basic reason we have these constitutional rights, and I think most people would agree, that it's better for a guilty person to go free than for an innocent person to stand condemned. There's supposed to be a little bit of a bias that way, and that's good. But if you think about the first part of it, it's not always comforting. It's a little chilling. But I have come to really see how public defenders are defending all of our rights when they are effective and active in the criminal justice system. I've come to respect them a lot.
Yeah, it's a tough job. Maybe are we ready to do the poll now? And Jonathan, as we start getting into the various strategies that people use, we'll ask, you can jump back in with any thoughts you have from your, okay? Okay, so we want to see, for those of you out there, what you're seeing happening with this, if anything, yet. So if you're not seeing it yet, we expect you will, because that's the reason we're doing this. It's an emerging issue. So have you seen the defense ask you or anyone else involved in your case, if you've been involved in new visas, ask for the immigration applications or the certification?
All right, just a few more seconds. I'm going to go ahead and close the poll. So get your answer in if you haven't yet. Okay, here we go.
Okay, so there's some of you, most of you haven't seen it yet, so this is just going to be thinking about what to do when it starts happening with you. Okay, let's try the next question. Okay, so for those of you who did or were involved in a case that got that request, did you or the attorney or the DA or whoever had to respond, did you supply part of the application? Did you supply all of the application? I guess we didn't put in, did you supply none of the application? Sorry about that. If you supplied none of the application, why don't we have you click part? Okay, so no one's had to supply the whole application. That's very interesting and very helpful, I think. Okay, the final question on this before we get into the strategy discussion is, those of you who did have to supply the part of the application, who did you give it, who reviewed it? Did the defense get it, or did only the judge get it? Interesting. Okay, so I think the 3367, that reveals kind of the strategy area that we're working here. So Wanda, let's get into some of the strategies, because I know you have been dealing with this for a while, with how you're dealing with Brady and related to both the certifications and the promise of certifications and also the case as a whole, if that's come up.
Okay. So, you know, as Jonathan was mentioning, as Jonathan was mentioning, yes, we are, as prosecutors, we're under obligations to turn over what's called Brady material, that which might tend to exonerate the defendant. And additionally, under that umbrella, there's a New York State Court of Appeals case, and I suggest people, you know, look to their jurisdictions to see how this has been interpreted. In New York State, there's a case, People versus Cologne. It's a Court of Appeals case, and it talks about the prosecutor's duty to disclose assistance. For example, in Cologne, it was relocation of a witness's grandparents, among other quote-unquote benefits. So, so we feel that the certification itself, the form that we're signing, and the information, in other words, as a prosecutor, I am going to disclose the fact that the people have been asked for a certification for a U visa and have signed a U visa certification. So that's how we have been dealing with the Brady issue itself, is to say, yes, arguably this may be considered a benefit, although we know that there's no, as Mike was saying earlier, there's no quid pro quo here. There's no, we are not, and we're very clear about managing expectations with victims in terms of letting them know that this is not a, a guarantee of anything, and that we are only one sort of piece of the entire process. And so it's very, very critical, I think, when you do this work, to really, really work very, very closely with immigration attorneys so that the victim understands and does not have expectations raised that somehow we are going to decide their ultimate status as opposed to other federal agencies, and that there are many, many hurdles beyond that certification that the victim, in conjunction with their attorney, may have to prove. So there are many other things that have to be proven, and that we're not signing this certification in exchange for their testimony. So that is the quid pro quo piece of this, is not raising expectations that that we are signing this in order to get them to testify.
Yeah, and so if you don't mind me asking, it seems like I'm always confused when I hear that DAs are holding off signing until the case is over because of Brady, because it seems to me that that is as much of a Brady issue as having signed it before they actually go to trial, because it seems to me it raises the same credibility questions. Is there any difference from a Brady perspective on when you sign it?
No, I mean, I think, and I'm sure Jonathan would agree, I mean, the Brady obligation is an ongoing obligation. So, and it concerns materials that are within our purview. I mean, there's not a necessity to, canvass or do, other agencies and get that which is not within our control. But certainly signing a U visa cert is within our control. So if we are doing it, we're disclosing the fact that we have signed that U visa cert.
Can I just say, I'm sure that almost any defense lawyer would think that the fact that a person is receiving, potentially some benefit by working with the prosecution is a relevant fact that they should be able to know. I think if I was actually cross-examining a victim witness, I would want to be real careful about it, because I think I could ask them, why are you doing this, and get an answer that I wouldn't like. I don't think it's really...
More fact than they might not have said before, you mean?
Yeah, they could say, now, there's a law that lets me come forward, and I'm not afraid anymore. I mean, instead of, oh, I'm trying to get something. I mean, there's different ways for people to speak about it.
I think Jonathan is absolutely right, and I think as we get a little later into the conversation, we talk about what's going to actually happen. I mean, a defense attorney could ask one too many questions and get a victim on the stand who's going to say, I'm terrified of this person, and I have done, I'm absolutely fearful and terrified, not only what he might do to me here in this country, but what his family members might do to my family members in the country of origin, in the place that I come from. So, I
think at this point you might try to object to the narrative answer.
Well, the defense attorney might try to object to the narrative answer, but if they're soliciting the information, I mean, you could, because obviously the person is going to be, prepared to talk about what they understand this to be in terms of the prep, the witness prep that's going to go into this. So, it can be. It's kind of like if you're asking, or you're the defense is seeking to impeach somebody about the fact that they were relocated and they got a different apartment, well, I mean, that just signals how frightening the defendant is if somebody is needing to be relocated in order to be in a secret, safe, new location, etc., away from this person. So, you know, I think we used to think it was, oh my gosh, we want to preclude any kind of cross-examination, any impeachment, any this, any that. And I think as we've gotten deeper into this and more sophisticated about it, you realize that, you know, it's a two-way street. Some of this the defense is not really going to want to ask, and some of it, you know, we're going to be preparing witnesses so that they are answering adequately about what led up to taking these kinds of, you know, in terms of in some ways, some of this is drastic steps to ensure their own safety.
Yeah, that's great, and that's a point that I've been making to the immigration lawyers a lot, which is that, you know, I understand the automatic desire is like, let's keep it all out, it's too scary, but you know, I do think it's worth thinking about, is there a way you can turn the tables on the defense with some of this, if necessary? You know, that they like I testified in a civil court case where I was able to do hearsay testimony that they couldn't have gotten in otherwise because I talked about what was in the immigration application. So I'm not necessarily suggesting that. I'm just suggesting open your brain to how, you know, you may be able to use this to your advantage sometimes. And so
yeah, there are a lot of prosecutors who just say, you know, come on, bring it on. You know, you want to go down the road, then let's go down that path. So it's a
that leads to what you and I were talking about, Wanda, when we were preparing for this, is we think it would be really helpful if one of the tools we could put together is like cross-prep questions for this kind of situation. Right. Maybe, Jonathan, you could help us with that. You could pretend you're the defense. You're thinking this might be another good webinar to do, is practice, you know, how do you prepare your clients if this is going to happen? I know. Sure. Okay. Now, Wanda, another thing you mentioned is that you've changed your the way you handle the actual case file, right? So that to avoid having to disclose more than you might otherwise have.
Well, we actually, it wasn't in the Brady context, but it was more in the, well, yes, okay. So we had one case where the defense actually subpoenaed or sought to subpoena the actual ICE file, okay? And what happened in that case is, and unfortunately, the case decision itself is sealed, but I was in the courtroom and present when it was argued. Our state court judge transferred it to the federal court because the request was for federal documents, which are by statute not available and not subject to disclosure. And so we had to be very careful about not looking to have that information. You know, sometimes you want to find out what your victim said in a variety of other contexts, but then if that stuff is not within your control and then you ask for it and you receive it, well then it's in your control and then you have to disclose it. So, you know, I think sometimes we want to be very be careful what you wish for. So when the judge turned to us and said, well, are the prosecutors seeking this, you know, material from the ICE file, you know, we said no. And so therefore the judge looked at the defense attorney in that context and said, well, you know what, they're not getting it. It's not within their control. They're not required to get it. So, you know, this is not going to be disclosed. So, and then in a criminal court case that we had, which is a published decision that I think is part of the materials today, is so we had a judge who had us turn over the certification itself, and the judge looked at it in camera to see what, if anything, it contained in terms of witness statements, you know, so not necessarily for Brady material. In other words, not for anything that it might contain for, impeachment value or tending to exonerate the defendant, but rather did it contain any witness statements. And we've been pretty spare in what is contained in terms of any kind of witness statements, and we attach the criminal court complaint, which is discoverable anyway, which the defense is getting at arraignment. So, we've had a decision that had us turn over the cert, but only for in-camera inspection and not to be turned over lock, stock, and barrel to the defense.
Okay, that's great. I think this is a good segue for Susan, but the one takeaway I want to reiterate here is that I think what you're doing, Wanda, is basically you're not keeping any part of the immigration application file except the certification, and that file is in the control of the immigration attorney who's covered by privilege, which is, it may be pierceable, but at least they have privilege. And for those who don't know what she's talking about, when she says that there's a federal law, Congress has said that the Department of Homeland Security cannot release a U visa or a volunteer petition or a T visa file to anyone except basically national security or like federal major crime investigation. So they're not going to be able to get it from CIS. If you're doing what Wanda's doing, the only thing they're going to be able to get, even if they win, is the certification, and they're going to have to go after the immigration attorney to get the actual content of the U visa file. So Susan, as a judge, what do you think of all this? And I know that you did deal with this when you were in the criminal court system, if you want to share your thoughts on, and anything anyone has said, and analogies that you may have, and what you think the options are for judges in these situations.
Oh my gosh, there's so much to talk about. But I first want to say that, like Wanda, I come from a state, California, that has an enormous immigrant population, and I think it has the largest growing immigrant population in the country, growing farther out than Texas or New York. And we have also a number of new judges in the state of California. Governor Brown has appointed a number of new judges, and all of us are constantly educating ourselves about the issue of U visas. And defense attorneys, district attorneys, and police officers like Mike are our best educators, because it's really important to remind a judicial officer what Mike was saying earlier, that a U visa doesn't grant immigration status, and it's only a first check, as Mike and Wanda were saying. And it's also important to think back to what Mike was saying earlier, the purpose of a U visa, which is to enable a victim to report a crime in a safe way. And if you as a judicial officer know this, or you're reminded of this, or there's expert testimony about this, it's going to help you when the issue comes before you as a judge to decide whether you are going to make someone disclose a U visa application or the information. So as far as suggestions for defense, DAs, police, and advocates, you are educators of the judicial officers on the bench. And it's important to maybe ask for a 402 hearing. We have what's called a 402 hearing in California, but it's an evidentiary hearing outside the presence of a jury to talk about the purpose and remind us judges of the purpose of the federal government granting U visas and the chilling effect that might take place if an entire U visa is suddenly turned over to either side. And I have actually had both prosecutors and defense attorneys do a subpoena for the U visa application and packet and bring it to court. Both sides have wanted the information and haven't gotten it in any other way other than to subpoena the entire file into the courtroom, which then triggered, in the cases I had, an in-camera review by me outside the presence of the attorneys to look at what was in the files. Now, I wasn't going to do that in-camera review unless I had an offer of proof that satisfied me as to why this information should be turned over to one side or the other. And I do think it's important, as Jonathan was saying, and as Wanda was also saying, that there be a really strict Brady analysis by a judge who's faced with the issues involving turning over the material of the U visa application, because Brady says clearly that due process requires that prosecutors disclose to the defense evidence that they have in their possession that is favorable to the accused and material to the issues of guilt or innocence. And the prosecution might not have these materials, but might know of these materials, or they know that there has been a U visa that a victim has applied for. The defense might know this too. So more often than not, what judges are seeing, at least in California, is the defense subpoenaing these, or trying to subpoena records involving a U visa into court. The judge has to figure out if there is any evidence that would be favorable to the accused, favorable in the sense that it might be exculpatory or impeaching of the complaining witness. And evidence is considered material, and this is, Supreme Court law, if there is a reasonable probability that a different result might have occurred if in the proceeding, in the trial, if the evidence had been disclosed to the defense. And let's face it, in domestic violence cases and sexual assault cases, these kinds of very serious crimes, the last thing you want is an appellate court or a Supreme Court to say there might have been a different result had this material been disclosed, and then have to start all over again with a new trial. So evidence has been found to be exculpating, and this is in a lot of Supreme Court cases if the evidence points indirectly to maybe the guilt of a third party rather than the defendant, or if the evidence supports one of the affirmative defenses that is being proffered, or supports the testimony of a defense witness, or impeaches the credibility of the victim. So there's lots of ways the defense can try, or I've seen defense attorneys try to get at the material in the U visa application. There's no right or wrong way to proceed, I think, by the attorneys trying to get this information, or the process by which a judge would make a decision. There's not a whole lot of case law in this area. Like Wanda was saying, that happened in New York. I think in California, more and more judges are doing these in-camera hearings once a defense attorney is making a sufficient offer of proof as to why they should get some of the material in the U visa application, or the DA for that matter.
Susan, if assuming that the DAs are setting this up, so really the only person who has the file is, except for the certification, is the immigration attorney. And the defense had subpoenaed me, and what would I argue that they wanted to actually get the file? What would I argue to convince you that you should be the only person who looks at it and only take out the parts that you think are relevant? What would I argue?
I think you should argue that there's a lot of confidential material in that application, that it's very similar to a judge reviewing a juvenile record. And in fact, an analogy and a way to proceed would be a case that just came out in San Diego, of all places, and it's J.E. versus Superior Court of San Diego County. It's a 2014 case. And that case required that the judge, well, it said that the judge should have had reasonable basis to believe there might have been exculpatory or impeachment evidence in a juvenile's records, but that the judge needed to conduct an in-camera hearing because a lot of stuff in those records is totally confidential. And in U visas, I mean, there might be names of minors, of children. There might be sexual assault issues that are really not discoverable, collateral issues regarding rape or other molestation. I mean, there might be a whole minefield of great things for the prosecutor to have so that they can make a motion to get in prior offenses and prior evidence going to intent or motive to commit the present crime. But I think that a good argument is that there's a lot of confidential material. There's, things like, I don't know, immigration material. There's, well, the green card numbers, whatever it is.
of relatives and things like that. Yeah, right.
Yeah,
and
relatives, things that are
people.
really private, and things that are totally collateral, and things that are not the purview of either side.
Okay.
So
sounds like people should look for, because since we don't have a lot of case law, they should. The juvenile might be a good context for people to look for analogies on what's relevant for ex parte in camera and why judges should do that.
yes, but
Okay.
I think there is a lot of confidential material in these records.
Yep. There is. And so then the other thing it sounds like we should is look at the things you talked about and actually argue to the judge on content that none of the stuff in this application implicates any of these things you said. It sounds like probably the main one's going to be impeachment of the victim. The victim hasn't said anything in her application that actually contradicts anything.
Right.
Okay.
I mean, since neither side really knows, other than
Right.
the immigration lawyer, what's in this material, it's kind of a fishing expedition at times for the attorney to say,
Right.
this is going to be relevant to my case. What's relevant is if there's any benefit being given to a victim or witness who's testifying. And there's not even necessarily any benefit in applying for a U visa because the application doesn't mean it's granted. But I can see giving over or allowing in a trial the fact that someone has applied for a U visa. I can also imagine allowing into a trial an expert on U visas to say that that doesn't mean anything that someone's applied or that there's been a certification signed, because it's up to ICE to grant these or not grant these, and just because
Right. It's not ICE, just so people are clear. It's CIS, but yes.
I'm sorry. Thank you. See my ignorance? This is why I need it. An expert in court.
You and I train judges on U visas, and you still can't remember all the details. So I think another takeaway for you attorneys is you need to educate your judges about what a U visa and what it isn't, and what a certification is and what it isn't, because they're not going to know unless you tell them.
Absolutely. So. You need to be an educator, not just a lawyer. You need to help us understand what this means and what it doesn't mean. But the fact that a judge is going to allow to come into the trial the fact that someone's applied for a U visa is no different than a judge allowing, as Wanda said, someone to say, yes, the witness got relocation fees, or our victim got a sandwich every time she came to meet with the DA. Those are things that
really
need to be.
Because one of the things we've learned from training judges is you need those analogies, because immigration status can be one of those things that people's brains just shut off when you start talking about it. And if you could say, but this isn't really different from something else you already know how to do, we find that that's really helpful.
Well, I've also found it very compelling, you know, like as Susan was saying, in the context of educating judges. I mean, it really merits mentioning that if we go sort of way overboard and over the top in a fishing expedition and saying every time this is has been applied for that, you know, we should give carte blanche to all kinds of questioning and impeachment and everything else, what we're really doing is taking the United States Department of Justice policies that are put into place to build trust, to build relationships with communities, to prevent certain sectors of our society to be preyed upon merely because they don't have legal status in the United States. I mean, you could take all these protections that have been put into place, turn them upside down and on their head by making it an avenue for just, you know, any sort of questioning and opening confidential files and attorney work product and everything else. So, you know, that is not what I think was meant when these protections were put into place.
I couldn't agree with you more, and you're defying the purpose the federal government had in creating the U visa or the T visa to begin with. If you're going to, you know, sort of vomit forth every piece of information in that application.
Which is a really good reason to bring in an immigration expert, which, Wanda, you had mentioned to me when we were prepping for this too, and you just mentioned that it's because that also helps educate the judge. You probably don't want them actually talking about the actual U visa in the case, but as you said, talking about what it is and why Congress passed it. I mean, you can't do hearsay, but you can share what Congress actually said and that kind of thing.
That's right. I mean, I have not done this yet, but I really think that we need to think about doing this. We need to think about, and I would love to hear from other jurisdictions who have actually brought in and used experts the same way we would have an expert to testify, not that this individual person is in fact, you know, a victim of domestic violence or battering and its effects, but rather that just what is it, to educate the jury, what is it to have experienced battering and its effects. In this context, it would be, so what are these immigration avenues and why were they put into place and what exactly do they mean?
And I think it's no different than the experts testifying about battered women, about when they come to court, when they don't come to court. You would want an expert to talk about battered immigrant women or battered immigrant persons. And so if you had this expert, the expert could talk about not just U visas, but also about battering.
Yeah, so ladies and gentlemen, we are running out of time, so I want to let people know some of the things we didn't talk about. I think this has been a really fabulous conversation, which is why we let it go, and hopefully we can do another webinar and talk about some of the things that you've been thinking about, Wanda, in terms of voir direing juries for anti-immigrant bias and dealing with immigration status generally in court. And I hope we could bring all of you back for another webinar and help maybe put together some samples and materials on preparing for this kind of thing. Does it sound like a good idea?
Sounds great.
Oh, that would be great.
Okay. And so, Natalia, why don't we move to the what strategies have you used slide, the very end, because we do, as they said, we want to hear from you. What are you doing? And I know some of you have sent some individual U visa questions. Natalia is going to give you my email address, and that's what I'm here for, is to help you with that. So you can send that to me individually after the webinar, and I'll get back to you. But in general, please send us any strategies that you're using, you're thinking on it, sample documents that you've used, cases that are relevant. And as we have been saying, right now there's not a lot of direct case law, so if you can think of analogous case law or decisions or briefs or anything that would be helpful, send it to us. We want to put all that together. We do want to encourage you to think about helping train your judges and district attorneys and law enforcement, and all of us on this call have been involved in that for quite a few years, and we're either happy to help you figure out how to do it or maybe find someone who could come do it for you, share what we've been using. And then in terms of resources, I think Natalia at the beginning already shared the link. Pretty much I think everything people mentioned on the call today is in that link now. I think that's right, Natalia. And then that questions at ACISA Help gets you generally to our TA. If you want to get to me directly it's Gail at ACISA Help, G-A-I-L. And just remind me that you are on this call. For those of you who are doing a lot of, or even any number of U visa or VAWA cases, we have 2 listservs that are free. One is VAWA Updates, and that's where we send out these kinds of constant updates of the work that we do with CIS, and that's only one way, so it's not a lot of email. And then Experts are for those of you doing a bunch of these cases and you want to share strategies with other people doing a lot of cases. Susan, do you want to mention right before we end the questionnaire that you designed for judges? Because we'd like to do that for everybody, I think.
Well, we just have a few brief questions. I think some of them were incorporated into the questions to all the participants today that we're sending out to California judges.
And you did that through the administrator of your court system. So
through
we would
a fabulous attorney, if she's listening, Bobby Welling, and the administrative office of the court. And as soon as we get the answers about what attorneys and practitioners are seeing in terms of immigration status being brought up in their courtrooms and how judges are dealing with issues brought up about immigration status and U visa, we'll share those answers with you, Gail. Maybe you can put them on the listserv.
Sure, and if any of you out there want to do something like that in your state, let us know, and we'll work with you on that. Okay, Natalia, let's turn it over to you and Casey to finish this up. I know you have some final things you want to do.
Well, thank you very much. This is Casey Gwynn. Thank you very much, Gail, Jonathan Moore, Mike Agnew, Wanda Luchabello, and Judge Susan Briel from San Francisco. We so appreciate it. We gave you the information earlier on the screens, but You've probably figured out by now that ASISTA is a great resource for you, and Gail Pendleton, in her OVW role as a TA provider, is a great resource for you in all of this. You're welcome to send questions to us as well at the Family Justice Center Alliance, or to reach out directly to Gail, and she will facilitate answers to those questions. Sorry that we were not able to answer some of the questions that came in, but feel free to email those to us or follow up with the attendees based on the information you got from the webinar. We're happy to assist getting you in touch with our presenters as well. The challenge for us, obviously, is substantial. The issues that come up are very constant, and we have to be advocates and ever vigilant in order to meet the needs of immigrant victims of family violence and abuse and sexual assault. And even as we were talking, I got an email from a colleague outside of California saying that they have a situation where a prosecutor's office is not choosing to sign any certifications until the case is completely over and appeals are completely done, which of course completely violates what we believe to be the spirit of federal law, and is an issue that we would challenge you to reach out to us with so that we can put you in touch with folks that can provide some technical assistance and input back to an office like that that is really not meeting the needs of true victims of violent assault that have rights under federal law that need to be honored and recognized. So thank you, Gail, and your whole team for putting on the webinar today. You'll note on the screen the reminder that this webinar has been recorded by the National Family Justice Center Alliance and will be available in our resource library, online resource library, to all of you. Again, we just want to quickly mention our conference. We look forward to having many of you join us. We have lots of teams coming in and individuals from all over the country. Just today, we got our post-certification for our conference thanks to Mike Agnew and Natalia Aguirre's work. So we have a 20-hour law enforcement track now for the Family Justice Center Conference that is post-certified for sworn law enforcement officers, not just in California, but is really available now to sworn law enforcement officers across the country. So it's a tremendous resource for those of you working in the field of gender-based violence. On behalf of our CEO, Gail Strack, and our Director of Technical Assistance, Natalia Aguirre, who hosted this today, Jennifer Anderson, who's been assisting Natalia today, and our whole team at the Family Justice Center Alliance, thank you for the work you do, and thank you for participating in today's webinar. Blessings on all of you and your work.